Welcome to Spoken Injustice, where we put the criminal justice system in the dock. Join me today as we delve into this month's new session, divided into three parts. Part 1 is dedicated to the latest from the Court of Appeal as we catch up with Libor trader Tom Hayes, gentle giant Oliver Campbell, and nurse Lucy Letby. Part 2 is dedicated to the latest news from the Criminal Cases Review Commission and in particular a major review of past cases recently announced which has received some criticisms. And finally, Part 3 is dedicated to the post office scandal, where we catch up on the latest developments with the inquiry and take a closer look at the text of the Post Office Horizon System Offences Act 2024. So grab a drink and take a pew. In our video Libor Scandal The Whole Truth, we left Mr. Hayes with his hope at its highest as the Criminal Cases Review Commission had then referred his case to the Court of Appeal. However, on the 27th of March 2024, the Court of Appeal dismissed his appeal and he was given 14 days to apply for permission to appeal to the Supreme Court. As you probably know, an appeal to the Supreme Court requires permission of the Court below or the Supreme Court itself, which may be granted only if the court below certifies that a point of general public importance is involved, and if it appears to the court below or the Supreme Court itself that that point is one which ought to be considered by the Supreme Court. On the 21st of May 2024, the Court of Appeal refused Tom Hayes' application to appeal to the Supreme Court. However, we were pleased to hear that the Court of Appeal certified that a point of law of general public importance was involved in their decision, and that it should be for the Supreme Court to decide whether that point of law is one which it ought to consider. The point of law referred here consists of the proper construction of the Libor and Euribor definition. As per Mr. Campbell, we covered his story in our video False Confessions Oliver Campbell 32 years later, and we were delighted then that his case had been referred to the Court of Appeal. The appeal took place over 2 days on the 28th and 29th of February 2024. However, it could not be concluded and a third day was deemed necessary. The final hearing took place at the Court of Appeal on the 21st of May 2024. Amongst other evidence presented, Mr. Campbell's counsel informed the Court of Appeal that the jury was never told of his co-accused testimony, in which he confirmed that Mr. Campbell was not at the murder scene and which categorically and fully exonerates him. However, it is anticipated that the court, if inclined to allow this appeal and quash the conviction, will do so based on safer and more generally preferred grounds, which are more likely to uphold the judicial process, namely new evidence. Specifically, new evidence from 2 psychologists who assert that recent scientific advances on neurodiversity cast serious doubt on Mr. Campbell's confession, later retracted, which was coerced by relentless police questioning, an approach now deemed inappropriate for vulnerable individuals like Mr. Campbell. However, we will have to wait for some time to know if the appeal is successful and on what grounds, as the Court of Appeal reserved its decision to a later date. Finally, on the 24th of May 2024, just 2 days after we released our video Open Justice Lights Camera Action, the President of the King's Bench Division, Dame Victoria Sharp, who oversaw Lucy Letby's appeal together with Lord Justice Holroyd and Mrs. Justice Lambert, in a brief hearing which you can find linked in the description below, announced that they had refused her application for permission to appeal on all grounds, and that they had also refused all the associated applications. She added that a full judgment will be handed down in due course. She also said that Lucy Letby put forward 4 grounds of appeal, each of which involved a submission that the trial judge wrongly refused the applications that she made during her trial. She did not give details of the associated applications. However, she added that any consequential applications can be determined at the time when the full judgment will be handed down. She finally reiterated that reporting restrictions are still in place, therefore we are precluded from making further comments at this stage. This concludes our first part of this news session. Now, turning on to our second part dedicated to the Criminal Cases Review Commission, or CCRC. If you recall, in our news session video, Michael Stone and Andrew Markinson update, we mentioned that an independent review into the CCRC's investigation into Andrew Markinson's convictions, conducted by Chris Henley KC, was underway. However, as we announced in that same video, the review, which was originally expected by 24th of October 2023, was delayed due to the complexity of the case. From an announcement made by the CCRC on the 18th of April 2024, we understand that Mr. Henley KC has now completed his review. Though the report is yet to be published, the CCRC confirmed that the report makes sobering reading, and that it is clear from his findings that the Commission failed Andrew Markinson. In anticipation to delivering this news, and perhaps in an attempt to somehow distract public's focus on the report's serious finding, a few days earlier, on the 15th of April 2024, the CCRC announced that it is analysing closed review cases involving murder or rape where the conviction was before the beginning of 2016, to pinpoint those where advances in DNA technology could now help identify an offender. The announcement states that the CCRC has identified almost 5,500 people who were convicted of murder or rape before 2016 and whose application to the CCRC were turned down. The project will assess cases in 3 phases. Phase 1 will pick out rape and murder cases which have come to the CCRC in which the identity of the offender is in dispute. Phase 2 will determine in which of these there might be fresh forensic opportunities given development in DNA testing. And Phase 3 will then reopen those cases to complete further analysis and testing. Initial work, which started in August 2023, suggests that about a quarter of these cases, that is over 1,000 cases, will move to the second phase of the project, with potentially several dozen ultimately being subject to new testing, although this number will become clearer as the project progresses. The project, though of course welcomed, has been criticised due to its limited scope. For instance, it will include only murders and rapes, therefore excluding other crimes such as attempted murders and sexual assaults, and will not include other DNA advances techniques such as YSTR profiling. This latter, we understand, was relied upon by Mr. Stone's legal team to reopen the CCRC investigation into his case with the view to be referred to the Court of Appeal. Additionally, Further criticism has been directed at the CCRC because the review will not consult forensic scientists until the final stage of the investigation. Some say this approach could result in cases being overlooked during the initial phase. According to The Guardian, Professor Christoph Champert, whose forensic pro bono work established that further DNA testing on key exhibits had the potential to exonerate Markinson, said, "In the aftermath of Andy Markinson's case, I can see that it may worry people to think that the CCRC itself will decide whether it is worth it to do extensive forensic work or not. I think this is something for a forensic scientist to do, even if it is a triage. I really think you need DNA expertise, not only awareness." Finally, on the 29th of April 2024, a further announcement by the CCRC confirms that 5 more post office cases were referred to the Crown Court, bringing the total number of cases referred by the CCRC to 76. This is out of 900 prosecutions, a drop in the ocean. Not only the CCRC action has been slow and inadequate in respect of these cases, but could also be counterproductive at this stage. As we can see from the announcement, the CCRC can still refer post office cases to the courts until the legislation comes into effect. However, if a case is referred by us to the Court of Appeal and the appeal is rejected, the applicant will then not be covered by the proposed legislation. We will revisit this point later on in the video when we examine the recently passed new law that exonerated hundreds of sub-postmasters involved in this scandal. This leads us smoothly to the third and final part of this news session, which is in fact dedicated to the post office scandal. But before delving into it, if you're finding this video interesting, like it to allow a wider circulation and subscribe to our channel to help us in our mission to humanize wrongful convictions. So let's start with the inquiry. Over the past 8 weeks, the UK Post Office Horizon IT inquiry has been focused on examining redress, access to justice, and the overall conduct of those who were in a position of trust, particularly those involved in the group litigation, bringing to light a variety of characters, featuring, and this list is not by any means exhaustive, the incompetent. See, for example, Elaine Cotton, an area manager who admitted she had no idea on how Horizon worked, as she had never used it herself, and that lengthy, binding witness statements presented as evidence in court in relation to computer logs, those signed by her, were in fact written by others on her behalf. We had the deceiving, see for example, Angela van der Berg, who despite being shown hard evidence, continued to deny that she knew as early as 2010 that the Horizon IT system could be accessed remotely. We also had the evasive, see for example Jane McLeod, Post Office General Counsel from 2015 to 2019, who has decided that her presence to the inquiry will not add any value, despite Sir William's disagreeing, and she cannot be compelled to give evidence as she has conveniently relocated to her native country. And those utterly detached from reality, see for example Paula Venables, Chief Executive Officer of the Post Office Limited from 2012 to 2019, who seemed to express more pity for herself than for the distress she had inflicted, readily attributing blame to the system, the very system she had overseen for over 7 years. Their integrity, meticulousness, and accuracy were unquestionably essential qualifications for their positions of responsibility. However, when they provided evidence to the inquiry, none of these qualities were apparent. These were the very people who directly contributed to the distractions of hundreds of honest and hard-working postmasters, and whose harrowing stories were partly captured in a video published on the Inquiry YouTube channel in March 2024 in relation to evidence provided by 189 people during the human impact hearings held by Sir Williams in London, Cardiff, Leeds, Glasgow and Belfast. A video that will touch even the hardest of hearts. If you have not already watched it, you can find it linked in the description below. Not to mention the effect that this scandal has had on the children of those wrongfully convicted, who for years had to deal with being marginalized from society or deal with their parents' absence due to them being in prison. Their lives turned upside down. We are pleased to see that a campaign group, Lost Chances for the Children of Sub-postmasters, has been set up. The group seeks recompense for opportunities and lost chances, as well as financial redress, and it is run by Katie Downey, whose family started a new life in France after her father, Tony Downey, was affected by the scandal. The group is also supported by Adi Misra, whose pregnant mother, Sima Misra, was wrongly sent to prison on his 10th birthday, and which left him contemplating suicide. However, they have already been warned that they might face a bit of an uphill battle from a legal perspective. Sam Fowles, a lawyer at Cornerstone Barristers, told Sky News that though he recognises that they have a moral case, warns them of the principle of remoteness, a principle of English law according to which the further you are away from the direct harm caused by the thing that went wrong, the less likely you are to receive compensation. However, is it all doom and gloom when it comes to post office scandals news? There was some cause for celebration on the 24th of May 2024 as the Post Office Horizon System Offences Act 2024 was brought forward and passed by Parliament before the general election. And here it is in all its glory. 12 short sections which finally clear the name of many honest and hard-working sub-postmasters after over 20 years of pain and sorrow. Taking a closer look, we see section 1 and 2, which set out the scope of the law, which we have already discussed in our video news session, Post Office New Law Unveiled. So there is no surprise there. Section 3 explicitly excludes all the cases that have been already decided by the Court of Appeal and where permission to appeal or substantive appeals have been refused, which is the point that we made earlier when discussing the CCRC news. Section 4 addresses an issue that we had raised in that same video, namely the identification of those caught by the Act. We are pleased to see that measures have been put in place to identify the quashed convictions and to notify the courts that issued those convictions, ensuring that a record is entered confirming the conviction has been overturned and that the affected individual is informed of this action. Criticisms have been directed at this law, particularly in relation to its exclusions. As we have already mentioned, cases prosecuted by the DWP and cases which have already been referred to the Court of Appeal and were refused are not covered by this Act. Also, some say the legislation leaves the compensation issue wide open. As we know, many have not even yet received interim payment. And finally, some criticized this law as some who were in fact guilty may be caught by this law. However, some of the issues could in fact be remedied. For example, exclusions can be remedied, though of course with the added legal expenses, by referring cases through the usual appeal channels as explicitly provided in Section 3, subsection 5, which states that nothing in this Act prevents a further appeal against a conviction that has been considered by the Court of Appeal. Given all the information that has come to light and is still coming to light from the inquiry, I will be surprised if those who had their appeal refused cannot find new evidence to bring their cases to the Court of Appeal again. Also, in relation to compensation, those who are caught by the Act can immediately access the option of settling their claim for redress for an upfront sum of £600,000 without the need to bring a formal claim to the Post Office. So, despite our initial reluctance, we now believe that this law was necessary given the overwhelmed and inadequate state of our criminal justice system, which regretfully stands accused in our dock as we once again deliver a resounding guilty verdict. The need for legal intervention to address wrongful convictions caused by the Post Office rather than through the criminal justice system underscores significant systemic failures. This situation highlights the criminal justice system's inadequacies in protecting individuals from corporate malpractice in the first place, and subsequently its reluctance to right wrongful convictions. It should have been the criminal justice system's duty to promptly identify and rectify these miscarriages of justice, but its failure to do so made a separate legal framework necessary. And what do you think? Let me know in the comments below. This concludes our news session. As always, join me next week with another exciting session. We look forward to usher you as we sit and rise in this unique trial.